Good morning, everyone. I want to welcome you to the February 27th, 2023 Land Use Hearing Officer hearing. My name is Susan Finch. I'll be presiding over the hearing today. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you so much. Please be seated. All right, thank you so much for your participation today in the Land Use Hearing Officer hearing. Let me start by introducing Mr. Tom Hisney. He's with the Development Services Department. He will introduce staff members that will participate in today's hearing, as well as go over any agenda changes. Mr. Hisney.
Yep. Good morning, Madam Hearing Master. Again, my name is Tom Hisney. To my right, we have Carmen Mason of Development Services staff. To my left, we have Cameron Clark of the County Attorney's Office. Other Development Services staff members that will be participating in this meeting on a case-by-case basis include Carla Shelton, Tanya Chapella, Sam Ball, and Chris Grangillard, Colleen Marshall, and Tim Lampkin. I'll now read into the record withdrawals and continuances from today's agenda. Item A1, Special Use Application 22-1188. The applicant was City Switch 2A, LLC. This application has been withdrawn by the applicant. Item A2, Variance Application 22-1422. The applicant is Mike and Nicole Mesra. This application has been continued by the applicant to the April 24th, 2023 Land Use Hearing Officer meeting. Item A3, Special Use Application 22-1563. The applicant is Karina Maris Okeke. This application is out of order to be heard and is being continued to the July 31st, 2023 Land Use Hearing Officer meeting. Item A4, Special Use Application 22-1657. The applicant is Todd Seamy. This application is out of order to be heard and is being continued to the March 27th, 2023 Land Use Hearing Officer meeting. Item A5, Special Use Application 22-1671. The applicant is Amber 2 of AP2 Services. This application is being continued by staff to the March 27th, 2023 Land Use Hearing Officer meeting. Item A6, Special Use Application 22-1690, Hoots of Carrollwood. The applicant is Hoots of Carrollwood. This application has been withdrawn by the applicant. Item A7, Variance Application 22-1716. The applicant is Deshae Martin. This application is out of order to be heard and is being continued to the March 27th, 2023 Land Use Hearing Officer meeting. Item A8, Variance Application 22-1720. The applicant is Melba Merced. This application has been withdrawn by the applicant. Item A9, Variance Application 23-0005. The applicant is John Grissar. This application is out of order to be heard and is being continued to the March 27th, 2023 Land Use Hearing Officer meeting. And finally, item A10, Special Use Application 23-0024. The applicant is Angela Quintana. This application is out of order to be heard and is being continued to the March 27th, 2023 Land Use Hearing meeting.
Thank you, Mr. Hisney. I appreciate it. Let me start today by going over our hearing procedures. Our hearing today consists of agenda items that require a public hearing by a Land Use Hearing Officer. I'll conduct a hearing on each agenda item and will file a decision within 15 business days following today's hearing. Excuse me, our hearing is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate and will decide all questions of procedure. I'll take evidence but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation is as follows. We have the majority of today's agenda are variances. The very last case is a special use. The order of presentation is the same except for the first part, and that is for variances, the Development Services Department staff and the planner assigned to that case go first. They have 5 minutes to present their findings regarding the variance application. On special uses, the applicant goes first. That's the only time the applicant goes first at that very last agenda item. And they have 15 minutes to present their case. So back to variances, Development Services goes first, then the applicant comes and they have 15 minutes, as I said. We'll then go to proponents. Anyone who would like to speak in favor of an application. Total time for proponent testimony is 15 minutes. The same is true next when we go to opponents. Anybody who would like to speak against an application. Also, everybody total 15 minutes. We'll then go back to the Development Services Department to see if they have any additional comments or amendments based on today's testimony. And then finally, the last word is with the applicant, who has 5 minutes for rebuttal. Regarding the time, I don't think we'll have an issue with that, but we try to keep the hearing moving along and adhere to the time constraints that are prescribed by the Land Development Code. If you are going to speak, if you are in the room, or if you are participating virtually online, if you could, when you start, give us your name and address for the record. We are recording this hearing, and we want to make sure that we have everybody's name and address correct and to what agenda item you are speaking to. If you're in the room, when you're done speaking at the podium, if you could see Joe at the end of the dais, he's with the clerk's office. He has a sign-in sheet. If you could also sign in with your name, address, and the application number that you spoke to, just to make sure we have everybody recorded correctly. Let me now turn to Mr. Clark. He's with the County Attorney's Office, and he will provide you the legal requirements for appealing a decision that is made by a land use hearing officer. Mr. Clark.
Thank you, Ms. Finch. Good morning. My name is Cameron Clark. I'm an assistant county attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following have standing to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It's the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. Safest course of action then is to write down any comments that you make today and to repeat those comments to the Appeals Board. Thank you.
Thank you, Mr. Clark. I appreciate it. All right. As I said, all testimony must be under oath. So if you plan to speak, if you could please stand, raise your right hand, and I'll swear you in. Also, if you are online, the same is true. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you so much. Please be seated. All right, Mr. Hisney, we're ready for the first case.
All right, on today's agenda, we have no vested rights cases, no fee waiver cases, no remands, no reconsideration requests. So that's going to take us to Section F of the agenda, which are site development variance requests. First item is F1, case number 22-1585. The applicant is Katie Ramirez. The request is for a variance to encroach into the wetland setback area and also a variance to lot development standards. Staff findings will be presented by Carla Shelton.
Good morning.
Good morning. Carla Shelton with Natural Resources in the Development Services Department. This request, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on October 26, 2022, is to allow for the construction of a home within the 30-foot wetland conservation area setback. Additionally, the applicant requests a setback variance to accommodate a single-family house on a corner lot zoned RSC9. For the wetland setback variance, per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a home within the 30-foot wetland conservation area setback. The applicant requests a 30-foot encroachment into the setback to allow for a remaining setback of 0 feet. For the lot setback, the subject property fronts West Sly Avenue on the north side and abuts platted unimproved right-of-way on the east side. Therefore, the parcel is a corner lot with a required front yard setback on the north and east sides and required side yards on the west and south sides. Per LDC section 6.01.01, the required minimum front yard setback for property zoned RSC9 is 20 feet. The applicant requests an 8.9-foot reduction to the required front yard setback to allow for a front yard setback of 11.1 feet from the east property line. Staff findings. If the variance for encroachment into the wetland setback is approved, a wetland setback compensation planting plan that provides equivalent square footage of compensation plantings to the amount of encroachment is required. The compensation planting plan must be submitted with the building permit application for the home construction. Finding number 2, the Environmental Protection Commission's consent order for case 2020-0066E for filling in the wetland on this property has been addressed and the homeowner is in compliance.
Let me just ask you a quick question. That
Yes.
completes your presentation, yes?
Yes.
Okay, cool. All right, the second finding about the consent order for filling in the wetland, that is asking in advance of filling in that wetland. Is that correct? That hasn't already happened?
No, it has already happened. It was a violation from
I see.
EPC for filling the wetland. They had several items that they required the homeowner to do to restore the property. Certain areas, you'll see on the site plan that they had to remove the fill, and certain areas they were allowed to keep the fill in the wetland, and then they had to do some wetland planting restoration, and EPC has already determined that that violation has been addressed and is in order.
All right, so they are in compliance, just for the record.
Yes.
All right, thank you so much. I really appreciate it. We'll go to the applicant. Good morning.
Good morning, Pedro Rodriguez, 607 West, Dr. M. Martin Luther King, Tampa, Florida 33603. I'm here with Ketis Ramirez, the owner, and Mario Parra, civil engineer. You want to say your name and the address?
Katie Ramirez, my address is 3925 West Crawford Street, Tampa, Florida 33614.
Thank you.
Good morning. My name is Mario Parra. I'm a professional civil engineer. My address is 3019 Banyan Hill Lane in Land O'Lakes, Florida.
Thank you.
Good morning. I don't really have much to add to the presentation of Ms. Shelton. We do have the request that has been outlined to allow us to build in the wetlands setback area. I can provide pictures of the lot and so forth if Your Honor wishes to see those pictures.
I would, because I think certainly the lot is constrained by the wetland, the existing wetland on the property. Would you estimate, maybe this is a question for your engineer, but would you estimate it's roughly half of those two lots, the
Yes,
southern half?
Yes, if I may, it's half. According to even the property, I believe the property appraiser's record shows it that way. All right. So these, this is Sly Avenue, and these two lots are the uppermost front lots, and the line right there, I believe that that's the wetline delineation area. So these lots, half of these two and this lot has wetlands. And they have been,
Sir, can you bring the microphone? It moves. If you could just bring it over to you a little bit as you,
Sure.
yes, perfect, thank you.
okay. So I'll put the other picture with the wetlands delineation for you to see. So that again is Sly Avenue on the north. And this is the red square or rectangle. That's what we are, my client is proposing to have as a structure, single-family home. And this line is the wetlands delineation line. And this is the 30-foot setback line. So what we are asking to do is to build within the 30-foot setback line.
And tell me about, you heard Ms. Shelton, my question about the filling in of the wetland, and now that's been found in compliance based on mitigation or remediation that you had to take, that's in compliance with EPC. But what stage of the process are you at in terms of the construction of this?
We haven't started. So there's no, we have to do the design of the home. We have to submit the plans and permits to EPC for final approval, because there's no final approval. This is more like a preliminary approval at this stage. So if we're allowed to construct within the setback area and also within lot development standards, then we can pull the permits and do the drain design and all that, provide it to the county for approval. Once it's approved, then we can go back to EPC for their own final approval so that we can proceed. So it's still, we're kind of in, not quite to the middle of it, I'm assuming at this point.
I see, all right.
Yeah.
That was my last question. Do you have
Okay.
anything else you'd like to add?
No, that's basically it. We believe that the having a residential home there in that lot is would further beautify the neighborhood. Is the one thing I do want to mention with regard to the to the variance reduction for the side is there is this is a right-of-way for the county, half of which has already been, I guess, vacated. I don't know if it's been vacated, but at least it's been used by the neighbor to the east. This right-of-way is not passable. It's just, there's no road there or anything. And so our request to have the setback reduced to 8.9 feet, actually 11 feet, is really not going to be affecting anyone, because that is really an unused alley, if you will. And at some point, if all goes well, we'll probably ask for that portion to be vacated anyway.
I see. All right. Thank you so much. If you
Thank
could
you.
all sign in with the clerk's office, and you're welcome to submit any documents you would like to the clerk for it to be in the record.
Thank you very much.
Thank you. All right. Now we'll call for anyone that would like to speak in support. Is there anyone in the room or online that would like to speak in support of this application? Yes, sir.
We were asked to,
You give us your name.
I'm sorry, my name is Mario Parra.
Thank you.
And we were asked to look at the situation to make sure that it is possible to come up with a drainage plan for the development that will ensure that there will be no negative effect to the neighbors or to the property. And we basically took the proposed footprint of the new building and determined that in effect all the drainage will be directed towards the south, which is the wetland area, and that also we know that there has been no construction work actually done except for what was necessary to do to remediate the conditions by EPC, which was basically removal of soil and planting of new vegetation. But in general, we confirm that that it is possible to do construct a new house without any negative effects to the site or to the neighbors.
All right, thank you for that testimony. I appreciate it.
Sure.
Is there anyone else that would like to speak in support of this application? Seeing no one, anyone in opposition, either online or in the room?
We do have someone online, I believe Sean Lopez.
All right, good morning. If you could give us your name and address, please.
Mr. Lopez, I believe you're muted. I'm going to unmute you now. Go ahead, Mr. Lopez.
Thank you. Can you hear me now?
Yes, we
I can hear you.
Good morning. My name is Attorney Sean Lopez on behalf of the adjacent property owner, Anacel Gonzalez. I believe she's in the room virtually as well. My office address is 700 7th Avenue North, St. Petersburg, Florida, 33701.
All right, Mr. Lopez, you said you represented an adjacent property owner. Which direction?
If you're looking at the property facing, it would be to the east.
So on the other side of that unimproved right-of-way?
Yeah, I believe my client here is here as well. Anacel, would you like to give the property address?
Sure.
Not sure if she knows it. Oh, there she is.
And so we're not hearing you. It looks like you're called in with the phone. If you could speak into the phone microphone.
I'll just give the address. The address is 3920 West Sly Avenue.
All right, but just to be clear for the record, that is the property that is on the east side of the unimproved right-of-way that is?
Yes.
Okay, all right,
It's
understood.
directly next to the parcel for the applicant. If you're facing the property, it would be on the east side.
Okay. Go ahead with your reasons for opposition.
Thank you. Pursuant to Section 110402 of the Land Development Code, the Land Committee may not grant a variance unless there's 6 specific required findings of fact. I'll go through all 6 and our reasons for why the variance shouldn't be granted today, and I'll go through them consecutively. Factor 1 is that the alleged hardship or practical difficulties are unique and singular to the property, which is requesting the variance, and they wouldn't be the same as any similarly situated property owner under the same circumstances. In the applicant's case, there's nothing unique about the presented need for a variance. Applicant seeks approval to develop a parcel of land which is predominantly wetland. By our calculations, that's a little bit over 65% of the property is wetland. Was not provided a copy of their wetland delineation survey. We went based primarily on the National Wetland Survey provided by Southwest Florida Water Management District. Applicants seeking to meet minimum buildable development standards. Florida in general, but Hillsborough County specifically, is covered in protected wetlands, and this exact situation is pretty common enough that the LDC defines wetlands as environmentally sensitive areas and prohibits activity that would otherwise disturb an environment unless specifically approved by the EPC. Moreover, the LDC or the Land Development Code provides for the application of a wetland encroachment permit in such matters that require encroaching into the wetland area. Therefore, it is our position that the remedy is not applying for a variance at this point, but moreover, applying for that wetland encroachment permit. Factor 2 is that the code would not deprive the applicant of rights enjoyed by similar property owners. To the contrary, it is our opinion that the code addresses this exact matter for which applicant seeks relief. The code details the steps with which the applicant should follow in order to seek approval. Specifically, section 40114 of the LDC requires that a natural resource permit be applied for and reviewed pursuant to procedures for issuance of a development permit. However, any piece of parcel or land containing wetlands, such as the one in question today, a natural resource permit shall not be issued until an application has also been reviewed and approved by the EPC. As part of the review, the EPC may require an applicant to include aerial views of the wetland, a soil survey, a wetland delineation survey, site maps, proposed development plans, a recovery plan, plan calculations for pre- and post-development runoff and volume discharge into the wetland, evidence that Swift Mud, which is the Southwest Florida Water Management District, or the Florida EPA, that a permit has been applied for, that the Army Corps engineers may need to be consulted. And clearly the code is articulating how an applicant may move forward when their property contains wetlands. Again, it is our position that a variance would not be the way to start. Maybe not now, but potentially in the future, a variance could be applied for to seek a variance to the required minimum buildable setbacks and things of that nature. And we don't have any issue with that, but I think we're kind of putting the cart before the horse. Third factor, the variance if allowed will not substantially interfere or injure the rights of other property owners if the variance is allowed. Unfortunately, the disturbance of any wetland area will have an impact on the environment, and any impact on the environment can have a potential impact on the community at large. Wetlands control the movement of water and overall quality of water entering the soil. They also function as reservoirs during the rainy season. Moreover, wetlands function as a habitat for several native and endangered Florida flora and animals. If wetland disturbances were not such an important concern, the LDC would not have carved out sections to protect and limit the destruction of wetland areas. And the matter is of great public importance to the adjacent homeowners, as any alteration to the applicant's property may divert additional rainwater onto another property instead of the wetland. Upon information and belief, and I think by prior testimony has been kind of confirmed here, that the applicant has been dumping fill material onto portions of the wetland on their parcel. Since the fill material has been poured during the rainy periods, the adjacent homeowner, which is my client, has exhibited standing water several inches high, and the only articulable change in the last few years' time has been the fill material on the applicant's lot. So it is our position that should the wetland setback buffer be completely or partially removed or encroached into, that there's no saying how much water may divert into the adjacent property without any proper analyses. And again, the applicant could file for a wetland encroachment permit. I'm not aware if they already have, but these exact analysis and mitigation procedures would be addressed upon that EPC review, applying for the permit, and so forth. Section 4, or the fourth factor, is that the variance is in harmony with and serves the general intent and purpose of the code. The variance that is being requested today is, in our opinion, premature and does not serve the general intent of the Land Development Code. The Land Development Code specifically prohibits alteration of wetlands unless approved by the EPC. And the only thing that I believe that has been approved by the EPC is rectifying the unapproved fill material that's been poured on the wetland area. Moreover, the placement of any permanent structure or other impervious surface is specifically prohibited except for activities carved out in sections 40107B of the LDC. The general intent of the code provides a path forward for the applicant. I mean, unfortunate for the applicant, the procedure and path forward is arduous, but it's available. The area the applicant desires to alter is part of the National Wetlands Inventory, and it is designated as semi-permanently flooded forest, a semi-permanently flooded area that is designated forest. As such, this land is subject to the provisions of the Clean Water Act and may require a permit from Swift Mud and evaluation by the Army Corps engineers. I'm not aware of any of that's been done. Fifth factor, the situation is sought to be relieved does not result from any illegal act, but result from the action of the applicant. I mean, outside of the dumping that seems to have been rectified, we can see that we don't believe there's any illegal action or activity from the applicant. As to the last factor, allowing the variance will result in substantial justice being done, considering both public benefits intended to be secured by the code and any individual hardship that will be suffered by the applicant should the variance not be granted. It is our position that the variance will not result in any substantial justice nor provide any great public benefit. The only thing a variance may do is provide for the illusion of a shortcut to achieve the applicant's goals. The code is clear. It provides for procedures which the applicant may follow in order to build on the parcel. The code provides for the application of a wetland setback encroachment permit, review by the EPC, application for a natural resource permit, application for a permit to Swift Mud or the Army Corps of Engineers for mitigation stamps. If and when all that has been approved, only then it is our opinion that the applicant can apply for a variance to seek variance from the restrictions found in 40107B, which doesn't allow for the building of a permanent structure or impervious surface materials. In summation, I mean, there's nothing unique about this applicant's request, nor is the applicant affected differently than a similarly situated homeowner or who owns a wetland parcel. The code provides a path forward for the applicant, and until such time as the applicant has followed the codes, I mean, a variance would be premature. In light of the foregoing, we respectfully request that the applicant's variance be denied in favor of following the code provided under the LDC, with leave to reapply once the code remedies have been fully exhausted. Thank you.
Thank you. Mr. Lopez, let me just follow up real quick before we leave you. I understand your argument, and I actually wrote down the question was that I had while you were speaking was, I think you used the phrase putting the cart before the horse. And so I believe you just answered this question at the end of your presentation, but just for the record so I understand. If not the variance going first, is it your opinion or suggestion that this applicant should apply for all of the Swift Mud, all of the regulatory permits prior to obtaining a variance? Is that what you're asserting?
Absolutely. I mean, I think the code is very particular about how wetlands are to be handled. The only issue I see here that may require variance is requiring an exception to 4.0107B. But in order to even get there, I believe they need to have an approval with a natural resources permit, they haven't even, from my understanding, applied for a wetland encroachment permit. And I mean, the county is very specific that would even initiate review by the EPC. And if it was approved and then they want to build the home, then I'd see why they would need to apply for a variance to build the home. But we don't even know if we get there yet. I mean, I believe approving it now would send the wrong message to the applicant saying, okay, well, I have that approval. I should be able to build build on this parcel, but that's not how it works. And I mean, I think we have larger overarching issues in effect here as well. I believe that this parcel of land in the wetlands area is governed under the Clean Water Act. I mean, if you review Swift Mud's wetlands, what their version of wetland delineation is, I mean, it's clearly designated as part of the National Wetlands flood map. I mean, I think allowing any sort of articulable path forward without following the procedure set forth may set bad precedent, and it may send the wrong message. And I have very large concerns for my client next door, because, I mean, they poured a little bit, although it's been fixed, but she showed me pictures of what happened after they put some fill material on the property. I mean, she's had standing water several inches high that's flooded portions of her property. I mean, there's a reason why this piece of property hasn't been developed and why 3/4 of the property is designated wetland. I think it may have a very overarching effect if we were to divert watering in any direction other than southbound. But sorry, I think I've gone off on a tangent. I hope I answered the question.
All right, thank you for that clarification. I appreciate it. Is there anyone else that would like to speak in opposition to this request, either online or in the room? All
Ms.
right,
Gonzalez, do you want to add anything?
Excuse me, who was that speaking?
I was asking if Ms. Gonzalez, the property owner, wanted to add anything.
We'll get to that point in the procedure of the hearing, but we're not there yet, so hold tight. All right, so seeing no one else in opposition, we'll go back to Development Services. Ms. Shelton, can I ask you a couple of questions? Thank you. So you heard the testimony in opposition and the question about Mr. Lopez's assertion that the property owner should go and get every other permit required prior to this variance. And what is the process? Is a variance required to encroach into that wetland area setback first before those other permits could be entertained?
They could apply for a building permit that would be reviewed by Natural Resources. However, the permit would not be able to be issued until a variance was granted.
So that variance is required before they could get what Mr. Lopez said, a wetland encroachment permit. It could not be approved or denied unless the variance was decided.
Correct. The variance is the wetland encroachment approval.
All right, thank you. And that was it, my only question. Thank you so much, I appreciate it. Mr. Hisney, anything else before we move on?
No, ma'am.
All right, thank you. We'll go back to the applicant, who has 5 minutes for a rebuttal.
Thank you, ma'am. A few things with regard to this request. We're requesting to build within the wetland setback area, not on the wetland per se. So I understand that it affects the wetlands, but it's not the wetlands in and of itself. Also, whether there has been water, standing water on the neighbor's property, as alleged by counsel for the neighbor, that's uncontroverted here. There's no proof of whether that's as a result of any filling or if it was like that before. So we don't have much information other than someone saying, well, the filling that was put in is causing this standing water. And with regard to the rights of others, well, again, we're trying to just build a house. It's not. It's in a residential neighborhood. It's going to be a nice construction. So whatever is done, it's going to be according to code. It's going to be according to the designs that would minimize any impact, negative impact on the neighborhood. So with that, I'll pass it on to Ms. Ramirez, who will just say something too.
Okay, thank you.
Go ahead. Get these. Thank you.
I'm sorry for my English. What I understood from the guy, that I gotta go for different permits. Before I bought those lots, that property, I came to the county and asked the county, and they told me that I gotta go to EPC. I went to EPC and just follow whatever the EPC told me to do. I just did whatever they told me to do. If I miss any permits or anything, I didn't know. I really don't know. Thank you.
All right, thank you so much.
Yes, I would like to just point out the actual physical conditions of the site. This is the property we're talking about. This is the wetland area.
Sir, can you pull that microphone, just pull it over towards you? Thank you.
Certainly. This is the site that we are proposing to develop, and this is the wetland area. This is the neighbor to the east and neighbor to the west, and in general, the whole south side of the street has been developed except for this one lot. In general, the encroachments into the wetland have been happening at different occasions, including for the neighbor to the east. Of course, right now, a wetland delineation can only be shown on this side because that's the only one that has not been developed. But in general, the conditions of the site indicate that a further development or the development of that particular site will really not change the conditions that are presently in the area. So anyways, but I just wanted to make sure that it is understood that the site the entire street has already been developed except for that one site.
Thank you very much. Does that conclude your presentation?
Just one thing in
All right,
closing.
thank you.
As I stated before, whatever permits are necessary will be obtained, whether SWIFT mod or whichever would be necessary for this project to be done. So we're not interested in doing something that is not according to the law. Thank you.
Thank you so much. I appreciate it. So with that, we'll close variance 22-1585 and go to the next case.
Next case is item F2, variance application 22-1619. Applicant is Emily Janeth Linares Justas. The request is a variance to encroach into the wetland setback. Carla Shelton will present staff findings.
Good morning.
Good morning. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on December 5th, 2022, is to allow for the construction of a screen enclosure within the 30-foot wetland conservation area setback. Per Land Development Code Section 4.01.0B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the construction of a screen enclosure within the 30-foot wetland conservation area setback. The applicant requests a 15-foot encroachment into the setback to allow for a remaining setback of 15 feet. Staff findings. An administrative setback waiver was granted for the construction of a swimming pool within the 30-foot wetland setback under building permit HC-BLD-21-0021322. The encroachment of 15 feet was approved per the Land Development Code requirements of Section 4.01.07B4. This waiver applied to the swimming pool and deck only and did not include a screen enclosure. Screen enclosures are considered to be structures and require a variance.
Thank you so much. I appreciate it. Is the applicant here? Good morning. Give us your name and address to start. Thank you.
Good morning. My name is Emily Linares. My address is 8321 Price Drive, Tampa, Florida, 33625 zip code.
Thank you.
My English not very well.
No problem.
She can help me.
Okay. You give us your name and address too before you start, if you're going to translate.
All right. Hello, my name is Asalia Martinez. I live at 8422 Aiken Court, Tampa, Florida, 33615. And I'm here to translate, so she will speak, and then whatever she can't get out, I will proceed to jump in.
Perfect. Go ahead.
¿Tú vas primero? Tienes que decir, después yo digo.
Okay. Okay. I have an original plan here.
She's going to show a picture of her original plan.
Okay, I have the plan. Okay. We have the plan with that line area here.
Could you bring the microphone over to you? Yeah, perfect. Thank you.
Sorry.
No, that's all right. Go ahead.
Okay. I construct the pool for my patio. I have the plan here for the pool. But I have a permit for pool, the permit, but aquí tengo las evidencias que fue construida la piscina para que llevara originalmente un screen.
She said that she originally, sorry.
There you go.
She said that she originally had to, she had the concrete and everything set up to build a screen, but because of the money at the time, she only built for the pool. And she is showing pictures of where the screen where originally would go, and it would only be 14.5 feet into the setback.
Todos mis vecinos que han construido han colocado screens.
And she's just showing that the setback also in that her other neighbors have also have the screen in the same type of area. Hers is just a little farther back.
Porque tenemos animales un poco salvajes en el área.
Ajá.
Explícale.
Y después, oh, sorry. And then she's just showing pictures of the type of wildlife that is around and that why she would want to have a screen set up.
Is that in her backyard?
No, it's not in her backyard. It's in the playground area because they have a Facebook page and they post of what is going on in the area and stuff like that. And that's her.
Estos son animales que han caminado por las calles de la urbanización. Hemos visto culebras.
She doesn't have a picture, but she says that they have been snakes in the backyard because of where the wetland is. There is a white fence right there to separate, but there's still animals that do come across and walking around in people's backyards and her backyards, etc.
So the animals you're showing pictures of are in her neighborhood?
Yes.
All right, thank you.
Sí, ese es como un website del community.
I see. Thank you.
Ajá, tengo también tengo los planos de la compañía que me va a hacer el screen.
And then she does have the permits for the blueprints of what the screen would look like and the feet, pero ponlo en el medio.
O sea,
Eso es todo.
eso es todo. Y que bueno, que queremos por la seguridad. I want my screen for the security for my family, for me, for my children.
Yes, she's asking for the screen just for protection. It would be only 14.5 feet in to the setback. It would not be directly into the wetback or the wetland area. And she would just like the screen to set up. If there's any extra permits that she needs to get, she will. And ¿qué más? ¿Qué más del área?
Que tenemos atrás mucho bosque y todas esas como hojas nos caen en la piscina. Ya.
And then the other note is that she does have a lot of trees coming in from the wetland side, so they do overbear into her side of the property. They get into the pool, they get everywhere, and it's just more inconvenient. But other than that, safety, and she wants to make sure that she can be able to leave her children outside and be able to let them play in the pool without being worried.
All right. I have two questions real quick. One
ma'am.
is, the staff report says that you're asking for a 15-foot encroachment, not 14. I just want to clarify what the request is.
Let me just double check. ¿Va a
Okay.
ser 15 o 14? ¿Verdad? Es 15, ¿verdad?
Creo que, let me see.
Porque aquí dice 15, entonces... Ah,
¿Qué busca? Yo creo que es 15.
sí, es 15,
Es
¿verdad?
15.
Yes, correction, it is 15.
It is 15.
Sorry
Okay,
about that.
And that's okay. And then the other question is just to ask if you've talked to your neighbors about your plan to put in the screen.
Yes, she sent out 30 letters to all her neighbors and made sure she sent 2 copies just to make sure they all received it.
And did you hear back from anybody?
No, ma'am.
Okay, that's all I had.
All right.
Thank you so much. If you could both sign in with the clerk's office. Thank you for your time. All right, we'll go to anyone who would like to speak in support. Anyone in support of this application, either in the room or online? Seeing no one, anyone in opposition to this request? All right, no one? Development Services, anything else? No, ma'am. Okay, and then ma'am, you have the last word if you like it, but you don't have to take it for a rebuttal. Nothing else? Okay, thank you so much, I appreciate it. Then with that, we'll close variance 22-1619 and go to the next case.
Our next case is item F3, variance application 23-0001. The applicant is WWS 19022 Gibsonton LLC. They're requesting a variance to encroach into the 30-foot wetland setback area. Staff findings will be presented by Carla Shelton.
Busy day for you.
Yes. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, Section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on February 8th, 2023, is to allow for the construction of various site improvements within the 30-foot wetland conservation area setback. Per the Land Development Code, Section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the construction of a building, drive lane, retaining wall, and an electric transformer within the 30-foot wetland conservation area setback. The applicant requests a 15.49-foot encroachment into the setback to allow for a remaining setback of 14.51 feet. Staff findings. Number 1, variance 20-0804 was previously granted for an encroachment of 15 feet into the setback with an overall encroachment area of 1,018 square feet. This request is a revision to allow for an additional 0.49 feet of encroachment depth, but a reduction in the area to 962 square feet of encroachment to accommodate changes made to the site during construction. Finding number 2, wetland setback compensation planting that provides equivalent square footage of compensation planting to the amount of encroachment has already been planted on the site.
Thank you so much. I appreciate it. Is the applicant here? Good morning.
Good morning. Ann Pollock, Fletcher Fisher Pollock, 433 Central Avenue in St. Petersburg, representing the applicant today. The variance request today this is something of a irregularly shaped property, and the east side is primarily wetlands. So in order to allow the development to have adequate building dimensions, parking spaces, circulation, et cetera, the LUHO approved a wetland setback in 2020, which Carla mentioned. It allowed the encroachment 15 feet into the setback from the 30 feet required. As she discussed, it approved an encroachment of 1,018 square feet with an improved mitigation conservation area of 1,307 square feet, so well above the impact that was being proposed, almost 300 feet more. It also approved the conservation plan to allow plantings and landscaping in the remainder of the setback area, as well as the retaining wall that together would keep the area in a natural state and prohibit access to the general public. The LUHO at that time found the request met all 6 requirements. So the developer ended up getting construction plan approval, and in 2022 recognized that some of the changes that were required would actually affect the wetland setback that had been approved. These changes included 2 things. One was shortening the stem wall, which overall ended up reducing the wetland setback encroachment, and then revising the location of the 7 by 7 foot TECO transformer pad from the front of the property to the rear of the property. And you can see here in this blow up of the site plan, the red bubbles show what was originally approved for the encroachment area. The green shows what is encroaching now, and the purple shows the conservation mitigation area, which has not changed. Going from red bubbles to green stripes reduces the overall encroachment by 56 feet, and actually increases the ratio of encroachment to mitigation because the mitigation area was not changed as part of this. I can go through the cross sections, but generally, they're in the site plan, and I'm happy to go through them in detail if you wish. But generally, C here shows 15 feet of undisturbed buffer and 15 feet of compensation. Cross section B shows the reduction of the setback encroachment by about half of what was proposed before. This is all due to the dealing with the slope there. They were able to move the stem wall northward. In A, it reflects the stem wall having moved forth to deal with the slope, and there's a little extra there encroaching, but no further than 15 feet into the wetland setback. And D, at the north, shows the location of the transformer pad, which sits in an angle. And for the most part, it's only the tip of that far western side that goes the extra 0.49 feet into the wetland setback, beyond the 15 feet that was already approved. So how did this happen? The applicant learned when it was moving forward with its construction that the primary feed for the electric lines actually runs along the rear of the property, not the front.
Ms. Pollock, could you bring that graphic down just a little bit so I can see the front where they moved that TECO pad? So the green is that pad that was now moved to the rear of the property?
Right. This is the transformer pad. It was originally supposed to be down here.
Oh, it was originally supposed to be in the rear. I see.
And I'll show you why we moved it. If you see this here, the primary feed comes right here. And so to put it all the way down on the southwest end would have been a tremendous problem. And this really made more sense. And what they discovered, what happened, and this is all, everything's existing, to be very upfront about that. Everything's been built. Because of the encroachment setback approval, there was the understanding that we got approved a certain amount of square feet and a certain depth of encroachment. And so when the revisions to where everything was placed, the applicant thought, well, this is not a problem because we've already gotten the approval for that much square footage and that much encroachment. But then it turned out, no, the legal process is if you want to change the actual location of stuff, you have to come back. And so that's why we're here. All in very good faith and, you know, nothing shady, but that's basically how we got to here. So, and they made the determination really that to reroute the transformer and leave it down on the south end would not only cause a big delay and a large expense, but it would require additional modifications to the construction plans, the signage, the layout, and either potentially a reduction in the functional use of the site, which is what we were trying to improve, you know, get approved in that original wetland setback encroachment, but it could potentially lead to further impact into the wetland setback as the directional bore of the lines actually came down on the west side of the building, which is already in the wetland setback, so potentially causing further impact to the wetland setback. So, you know, we're still dealing with this unusual site, the irregular shape, the wetland limiting what can be built there. But now, because of the unusual shape and design of the property, as well as where the electric transmission line is from the master development, we're sort of under more hardship circumstances here. And there really was no other place to put it. Potentially, they could have put it in the north, the northeast end, but what they determined there was, first of all, no other properties are being affected by where it is located because it's against the road and it's against the wetland. But on the other hand, in the northern boundary, they would have had to encroach into the landscape buffer. And really the feeling was that that would go counter to the intent of the code, which is to provide some sort of visual buffering between the commercial use and the roadway. The amount of wetland setback had already been approved. The proposed revisions actually decrease the area of the overall encroachment. And the TECO transformer is in the most northerly and easterly area that it could possibly be on this west side of the property. And of course, we still do not intrude into the wetland itself. we have a greater ratio of mitigation conservation area to wetland setback, and the remainder of the setback area is planted into a natural state and maintained in a way that's not accessible to the public, so it will be protected. Our environmental scientist, Dale Merriman, is here today. If you have further questions, the applicant representatives are here and virtually, and up until, we may have had somebody from TICO, but he may have had to get off, who would have been able to answer any questions you have as well. But with that, I'm here for questions.
Just for my own information, if this is all existing, how did this come to light?
I believe that they went in for another type of permit of some sort. I don't recall offhand exactly, but it was to go in for another permit, and at that point they discovered that this had moved forward inappropriately. But they had gotten all the permits that they needed up until this point.
I see. But I guess in the bigger picture, although that encroachment is slightly larger, the overall square footage of the total encroachment is less than what was
Correct.
previously approved.
Correct.
All right, that was my only
and the 15.49, it's just that tip of the,
Right.
it's very little.
I
So
understand.
it's a pretty minor change, so.
All right. I
Thank you so
understand.
much.
Thank you for your time. If you could please sign in with your name and address, and also submit any documents you care to. All right, now we'll call for anyone that would like to speak in support. Anyone in favor of this application, either online or in the room? Seeing no one, anyone in opposition to this request?
Oh, hold a second. This is Sid Jordan. I would like to speak in opposition and support. Is that acceptable?
Yes, absolutely. If you give us your name and address, go ahead.
Sid Jordan, address 142 West Platt Street. I'd like to answer the question that was asked of Ms. Pollock relative to how was this found out. And how this was found out is we had submitted for our final certificate of occupancy inspection. And one of the requirements of that is a review of the variance. And really what we're asking for here today is the variance did not state that a transformer could be within that square footage. And if the word transformer was on the variance, then we would have been in full compliance of the original variance. So really what is being asked here today is the allowability of adding the word transformer to the previous existing variance is what the request is. And we did do everything we could do to mitigate, as Ann pointed out. We lessened the impact, and we thought we were doing the correct thing by not either trenching or jack and boring through the wetland areas. This was the shortest distance to install the transformer that was viable for the project. So as the developer of the project, we tried to do everything within our to mitigate any impact on the environment. But you know, how it happened was we had filed for our CO and was granted a temporary CO, and we're here to clarify the variance so that we may receive our final CO. And I'm happy to answer any other questions that we were not able to previously.
No, that answered my question. I appreciate that additional testimony. Thank you so much. All right, so we'll close testimony and support. Anybody in opposition? We'll call one more time before we move on. Seeing no one, Development Services.
Madam Hearing Officer, we do have one more person signed up. I just want to make sure that they were, it's Charlie Potter, I believe. He signed up as an applicant, but I want to confirm that.
Yeah, he is our engineer. He was here available in case you had questions.
Oh, okay. Thank you so much. Yeah,
Thank
no
you.
questions. All right, so seeing no one in opposition, Development Services, anything else?
No, ma'am.
All right, thank you. Then Ms. Pollock, you have the last word if you'd like.
Just if you had, any concerns about what was originally approved, I believe that you are allowed to look at the previously approved variance
I have-
information. So
Yeah.
I have the copies of it if I would need to submit it into the record if you felt that was important, but otherwise I think you are permitted to look at what was approved in 2020.
Yes, of course, and I did actually.
Okay.
In preparing for this case, the staff cited the prior variance number, and I did pull it up and review it in preparation, so thank you for that. I
All right,
appreciate it.
thank you, that's it.
All right,
Thank
then
you.
with that, we'll close variance 23-0001 and go to the next case.
And that concludes Section F of our agenda. It takes us to Section G, sign variances. We have one case, item G1, application number 22-1672. The applicant is Creative Sign Designs requesting a sign variance. The staff report was prepared by Kim King, but the findings today will be presented by Sam Ball.
Good morning.
Good morning, Madam Hearing Officer. Sam Ball of Development Services. The applicant is requesting 2 setback variances for a proposed monument sign for Fawn Ridge subdivision located at the northeast corner of Citrus Park Extension and Fawn Ridge Boulevard. For the first variance, LDC Section 7030C1C requires a minimum setback of 15 feet from the road right-of-way lines for a monument sign with 1 foot of additional setback required for every foot of sign height or portion thereof above 4 feet. The subject monument sign will be 8 feet 6 inches in height, and as a result, a 20-foot setback is required from the Fawn Ridge Boulevard right-of-way. The applicant is requesting an 18-foot reduction to the required setback to allow a setback of 2 feet from the right-of-way line. For the second variance, LDC Section 7030C1 requires that all ground signs, including monument signs, shall be set back a minimum of 10 feet from any side yard property line. The applicant is requesting a 7.56 reduction to the required setback to allow a setback of 2.44 feet from the east property line. That concludes my report. Thank you.
Thank you so much. I appreciate it. Is the applicant here? Good morning.
Good morning. Addie Mentry, Creative Sign Designs, 12801 Commodity Place, Tampa, Florida, 33626. I had a PowerPoint presentation that somebody...
All right. I don't know if we have anybody from HTV. Oh, there you are. They can assist you.
Thank you.
Yeah, we have it loaded here.
Okay, so we're proposing a monument sign for the Fawn Ridge subdivision. The vicinity map, we're looking at the east side of the county, along with east of Sheldon in the Citrus Park expansion. Here's the community map. Fawn Ridge serves about 690 residential homes. Here is the parcel in question. The owners of Fawn Ridge have a strip of land that is 10 feet wide, known as Parcel A, on their plats that were originally approved in 1993. This land was designated in case there was any sort of expansion and for any reason of signage that would need to be placed on the property. It is owned by all owners of Fawn Ridge. So we are requesting 2 setback variances, one from the front setback from Fawn Ridge, which would be 18 feet, and the side variance from the adjacent property of 7.56 feet. Like I said, we are proposing 1 freestanding sign. It will be parallel to Citrus Park Drive, and it will be approximately 9 square feet and located at the northeast corner of Citrus Park and Fawn Ridge. This is the design of what the sign will look like. This is what it will look like from the intersection. This is a 3D rendering from the intersection of Fawn Ridge Boulevard and Citrus Park Drive. And here are some schematic dimensions of the square footage. It will be parallel to Citrus Park Drive, and that the width of the sign is 4 feet 3 inches, and it will be 8.5 feet tall. Here is the site plan where you can see the location. Here is a closer view. So there is the 2 property lines of parcel A. So we are set back from Citrus Park Road, Citrus Park Drive. That meets the required setback for that front setback. We are proposing the sign to be in the center of parcel A, which is approximately 10 feet wide. So we're about 2 feet off of each, 2 and some change off of each frontage due to the width of the sign. I did want to point out, although we are asking for the setback, that here is showing the new curbing from the Citrus Park expansion to the sign is 26 feet. So while we are asking for the setback from the parcel, our position is that it is far enough back from Fawn Ridge and Citrus Park. It is outside of the visibility triangle, while also being visible for all of those residents and their guests. So just some justification. Obviously, this is a large residential subdivision. It holds about 650 single-family homes, and Parcel A was approved in the original plat in 1993 as a placeholder, possibly for anything that needed to happen as far as signage. It was a part of the Citrus Park expansion plan, and from that, with talks from the HOA board and through project managers at Hillsborough, they did say they would reimburse the subdivision for the signage, and then they would support where the signage is going, because on the opposite side, there is no other piece of land to install a sign because of the wall that separates the structure wall that separates the subdivisions from the road. The new lighting system, traffic lighting system. There are utility easements there and landscape easements there, and also the adjoining property owner has a fence on the northwest side that would, and with all of those combined, would not allow for another place to have a subdivision entry sign for Fawn Ridge. So really, the driving factor is the improvements from the expansion plan really limited any sort of location for signage. Our position is that we wanted to make this as visible as possible for residents, and we need the setbacks because that land is so small, but we didn't want to make a monstrosity and wanted it to be tasteful. So we appreciate your consideration.
I just have a quick question.
Yes,
Fawn
ma'am.
Ridge has been there for a long time, obviously.
Mhm.
Was there a subdivision sign there previously?
No, there was not.
So this is new in that 10-foot strip?
Yes.
I see. All right, thank you so much.
Thank
If you
you.
could please sign in with the clerk's office, I appreciate it. All right, is there anyone who would like to speak in support? Anyone in favor, either in the room or online? Seeing no one, anyone in opposition to this request? All right, no, hearing from no one, Development Services, Mr. Hisney, anything else?
No, ma'am.
All right, then the applicant, you have 5 minutes if you need it, or choose not to. Thank you so much, I appreciate it. And we'll close variance 22-1672 and go to the next case.
All right, that concludes section G of the agenda. We now go to section H. These are the general variance requests. First case is item H1, application 22-1699. The applicant is Marco Anthony Hernandez. The request is variance to accessory structure requirements and variance to lot development standards. Staff findings will be presented by Sam Ball.
Good morning.
Good morning, Sam Ball, Development Services. The applicant is requesting 2 variances to accommodate an existing single-family dwelling and an existing accessory dwelling on property zoned AS1. The first variance is from LDC section 60101, which requires a minimum front yard setback of 50 feet and a side yard setback of 15 feet as required in the AS1 district. The applicant is requesting an 8-foot reduction to the required front yard setback to allow a principal setback of 42 feet from the southern property line and an 11-foot reduction to the required side yard setback to allow a setback of 4 feet from the eastern property line for an attached carport. The second variance is from LDC Section 61102E, which requires that accessory dwellings must meet principal building setbacks, except under certain circumstances that do not apply to this case. A minimum rear yard setback of 50 feet and a side yard setback of 15 feet is required in the AS1 district in accordance with LDC Section 60101. The applicant is requesting a 33.4-foot reduction to the required rear yard setback to allow a setback of 16.8 feet from the northern property line and a 3.2-foot reduction to the required side yard setback to allow a setback of 12.1 feet from the eastern property line. That concludes my report. If you have any questions.
Just a quick question on that accessory dwelling. The setback variance for the accessory dwelling to the north, is that considered a front yard?
That would be a rear yard.
Okay, I just wondered because of that adjacent parcel, it's labeled on the survey, and I just wondered what that was given its shape. I just wanted to clarify for the record. So it is a rear yard. That's an unimproved, not right-of-way. Okay. Thank you so much. I appreciate it. Let's hear from the applicant. Good morning.
Good morning. My name is Eva Ruiz. I'm a representative of owner. My address is 1705 Cower Road, Plant City, Florida, 33567.
Thank you. Go ahead.
Yeah, I don't have much to add. The only thing is when Mr. Marco Hernandez buy the property, he buy the way it is now. He don't add anything to it. He just asked around the neighbors about the mobile home. It's in the back and the north side, and it's existing mobile home in there. He renewed it for playground and after-school studies for kids.
That was exactly my question was
Yeah.
when he bought it, was everything where it is today?
Yeah.
So the mobile home and the single-family home, just as it is today. And
It was.
he bought it in, I'm trying to find his deed. Do you know off the top of your head? Oh, here it is. In 2021, I believe it says?
Yes,
Okay.
correct.
All right. I see there is a code enforcement violation here.
Yes.
And the violation, I'm looking in the backup, the date doesn't seem to pop. Oh, in August of 2022, which would be after the date of purchase, according to the deed.
Yeah, it was after the day he purchased, and Mr. Monsanto told him about the possibility of keep the way it is through the variance. That's why he applied for that.
Absolutely, I understand. But the code enforcement citation says failure to obtain a permit for the installation of a mobile home at the rear of the property. So how did that happen if the mobile home was already there?
He remodeled the mobile home. It was existing in there. It was there when he bought
and
it.
the same
Yeah,
mobile home,
yeah.
everything?
Yeah, when you see the when he bought it, they do a survey, and it's there in the survey.
Okay.
The
all right.
days before they bought it.
Okay. So he was remodeling the interior of the
The
mobile home?
outside.
The outside?
Yes.
All right. What was he doing, just for the record, to the outside of the mobile
Yes,
home?
nothing else. It's just the outside of the mobile home, siding, or how you call the.
Oh, okay.
Yeah, the
All right.
outside.
Okay. And then my last question is, has he or you as a representative talked to the neighbors
Yes.
about this?
We send the letters and everything. We resend the 5 first owners and then the 15 of them.
All right. And did you hear back from anybody?
Yeah, 2 of them, they call me and I explain to them and they say they now opposed.
All right. Thank you so
Okay.
much. I
You're welcome.
appreciate it.
I'd like to add the writing statement from Mr. Hernandez
Okay.
today.
Go ahead. Oh, you're going to read it or submit it into the record?
Submit it in.
Oh, that's perfect. Thank you
Okay.
so much. Yeah, if you could sign in and submit whatever you'd like.
Thank you.
I appreciate your time. All right, is there anyone in support that would like to speak for this application? Seeing no one, anyone in opposition, anyone against this request, either in the room or online? Seeing no one, Mr. Hisney, anything else?
No, ma'am.
Okay, ma'am, you have the last word if you'd like it, but you don't have to take it. All right, thank you so much. Then with that, we'll close variance, excuse me, 22-1699 and go to the next case.
Yeah, at this point in the hearing, may I request a short rest break, please?
Absolutely.
Thank you.
All right, so we will take a short break. The back of the wall, it says 11:20. Let's be back at 11:25-ish. Thank you. All right, welcome back, everybody. We're going to resume the February 23rd, 2023 land use hearing or 27th, sorry, I've had the wrong date, February 27th, 2023 land use hearing officer hearing. And Mr. Hisney, we're ready to call the next case.
Okay, next case is item H2, variance application 22-1704. The applicant is Jennifer and Glenn Cloversettle. The request is a variance to accessory structure requirements. The staff report was prepared by Isis Brown, but I'll present the findings at today's hearing. Applicant is requesting a setback variance to accommodate a proposed detached garage on property zoned RSC 2. Land Development Code requires that accessory structures shall be permitted in front yards at twice the depth of the required front yard or 50 feet, whichever is less. Such structures shall not occupy required side yards. This property is zoned RSC2, which has a minimum front yard requirement of 25 feet. Therefore, the required front setback for the subject accessory structure is 50 feet. The applicant requests a 29.9-foot reduction to the required front setback to allow a setback of 20.1 feet from the east property line. As shown on the site plan, the structure will meet the district's required side yard setback of 10 feet. According to the applicant, the structure will be less than 15 feet in height. Also allow me to point out that this parcel is accessed by an easement. Therefore, under the Land Development Code, the required yards on such lots are oriented with respect to the roadway to which the private driveway extension connects, as if the lot abutted the road. In the subject case, the parcel is accessed by an easement that connects to Alafia Ridge Road to the east. Therefore, the required front yard is on the east side of the property. And that concludes the presentation.
Thank you so much. Is the applicant here? Good morning.
Glenn Cloversettle, 7823 Alafia Ridge Road. My wife.
Jennifer Cloversettle, 7823 Alafia Ridge Road, Riverview, Florida.
Thank you.
He did an excellent job. He presented well. Essentially, we live between two roads. I have a southern easement that accesses my property, and what I've always considered my backyard, I learned is my front yard. Or my side yard. So essentially what I'd like to do is, since we access our property on the very southern easement of the property, it's on the east side, we were trying to keep that building in the northeast corner and avoid having to cut a whole bunch of trees and a bunch of other stuff and keep the green space and not have to build on the opposite side of the house. The other option is to build in what I consider my front yard, which would be very unappealing. So essentially that's why we're here. The area that I want to build in actually connects my neighbor, if I can speak today, my neighbor to the north, it's their backyard. My neighbor to the east, it's their backyard. So nobody can actually see my property from the road. I think our easement is over 400 feet long to get to where it's an interior property. Nobody will affect, it's not an eyesore for anybody, it won't. And I believe our neighbor to the north, he's also accessed by an easement. He faces the direct opposite direction I do, and he's also had build structures in the same area. So it's in line with what he's already has, and along with the neighbor to my east. That's really all I have for you.
Just a quick question. When you mailed out your letters to the adjacent property owners, did you hear back from anybody?
I did. There was some confused individuals as to why the papers had to go out, and one asked why I couldn't just do it, why I had to ask. I'm like, well, there's a process. But that was pretty much it.
All right.
Nobody seemed to care.
Okay. Thank you so much for your time and testimony. If you could both sign in with the clerk's office. Thank you very much. Is there anyone that would like to speak in support of this application, either in the room or online? Seeing no one, anyone in opposition? No one? Mr. Hisney, anything else?
No, ma'am.
All right, sir, you have the last word if you'd like. All right, thank you for your time. We'll close variance 22-1704 and go to the next case.
Next case is item H3, variance application 22-1712. The applicant is Robert Spinagle Jr. and Virginia Johnson. The request is a variance to lot development standards. Staff findings will be presented by Chris Grangelo.
Good morning.
Good morning. Chris Graulenard, Development Services. Here to present application variance 22-1712. The applicant is requesting a variance to accommodate a proposed addition to an existing family home zoned RSC4. Per LDC section 6.01.01, a rear yard setback of 25 feet is required in the RSC4 district. The applicant requests a 10-foot reduction to the required rear yard setback to allow a setback of 15 feet from the east property line for the addition. That concludes my staff report. Glad to answer any questions you might have.
No questions at this time, but thank you.
Thank you.
Is the applicant here? Good morning.
Good morning. William Malloy, 325 South Boulevard, Tampa, Florida. I think staff laid out the request pretty simply. It's just a reduction from 25 to 15 in the rear yard. Just a few anecdotes on that. We are asking first. This would be new construction. Nothing's happened yet. I think we're pretty satisfied with the variance requests as they were written, the responses in the application. We did send out letters, and obviously the site was posted. My office received no inquiries, and to my knowledge, there's no opposition to this request. And finally, I think there was one concern from Development Services, which I completely understood. This is just going to be an addition which will be integrated into the existing home. I think it contemplates a little bit more living space and a bedroom and a bathroom, no kitchen or anything, so there's no idea that this would ever be a third party or a detached use or anything like that. And that's all I have. Happy to answer any questions.
No questions, but thank you so much.
Thank
I
you.
appreciate it. All right. Is there any, we'll go to testimony and support. Is there anyone who would like to speak in support of this application? Seeing no one, anyone in opposition to this request? All right, no one. Mr. Hisney, anything else?
No, ma'am.
All right, Mr. Malloy? All right, then with that, we'll close variance 22-1712 and go to the next case.
Okay, our last variance today is item H4, application 23-022. I'm sorry, 0022. Applicant is AJI Fowler LLC. President of variance to lot development standards. Staff findings will be presented by Colleen Marshall.
Good morning.
Good morning. Colleen Marshall, Development Services. The request today is for variances to accommodate a proposed covered patio for an existing building on property zone CG. The applicant requests a 16-foot reduction to the required front yard setback to allow a 14-foot setback from the west property line adjacent to Club Drive for the proposed attached covered patio. Additionally, the applicant requests a variance of 24.5% to allow a maximum impervious surface of 94.5%. Happy to answer any questions.
I don't think so, other than just to clarify on the record, not clarify, but document on the record that when your staff finding says that when this was built in 1980, that maximum impervious surface ratio requirement did not exist in the code.
Correct,
Okay,
yes.
so this patio adds 700 square feet, is that correct?
Yes.
Okay, all right, that was it. Thank you so much.
Thank you.
Is the applicant here? Good morning.
Good morning. My name is Ryan Renardo, 10312 Bloomingdale Ave, Riverview, Florida, 33578. I'm the civil engineer working on the project for the applicant, AJI Fowler. Happy to answer any questions you may have.
I don't have any questions at this time, but thank you so much.
Okay, one thing I did want to just clarify, if you don't mind, real
Sure.
quickly, on the setback reduction, this is a double frontage lot, so we are subject to the front yard setback, even though this is going on a functioning side yard. Just wanted to add that for the record.
Right, from that western property line?
Yes.
Correct? Okay, yes, understood.
Okay.
Thank you. If you
Thank
could
you.
please sign in. All right, is there anyone who would like to speak in support? Anyone in favor of this request? Seeing no one, anyone in opposition? Either in the room or online? All right, Mr. Hisney, anything else?
No, ma'am.
All right, the applicant, anything else? All right, then with that, we'll close variance 23-0022 and go to the last case.
Okay, we don't have any appeals today, so that takes us to Section J, Special Uses. We have one case. It's application 22-1721. The applicant is First Watch Restaurants. They are requesting a 4 COP alcoholic beverage permit, which requires a separation waivers. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
All right, special uses, the applicant goes first. I understand the applicant is virtual, is that correct?
Yes, ma'am, I am. This is Brian Harris, 8725 Pendry Place, Bradenton, Florida, on behalf of First Watch Restaurants.
Good morning, go ahead, please.
I'm sorry, could you repeat that, ma'am?
Go ahead with your presentation.
Oh,
Thank you.
so we're First Watch Restaurants and breakfast, brunch, and lunch, and we're just seeking to be able to serve alcohol on our days. Our hours are from 7 a.m. to 2:30 p.m. So, I mean, it's short and sweet, but that is our desire, to be able to sell alcohol during those hours of operation.
All right, and because the variance is from the requirement to residentially zoned property, I'll ask if you heard back from any of the affected parties when you sent out your notice.
No, ma'am, we have not.
All right. Okay, well, thank you so much. I appreciate it. We'll go to Development Services.
Good morning, Tim Lampkin, Development Services. The request is a distance separation waiver for a 4 COP permit. This wet zoning is sought for the First Watch. Per section LDC 6.11.11.d, the following distance separations apply. Number 1, community uses. Number 2, residentially zoned property. Number 3, no more than 3 approved AB permits. The applicant requests a waiver of the being within 250 feet of residential property. The applicant did provide justification inside in their narrative, and staff finds that per section 6.11.11.e.3 provides the approval of the separation waivers that are special or unique circumstances exist. Number 1, the proposed wet zoning is separated from the residential development by a 2-lane roadway with a crosswalk to the east, creating a greater distance from the proposed alcoholic beverage permit, resulting in a pedestrian distance of approximately 700 feet from the front yard of the residential development to the restaurant. Second, the normal route of travel from the entrance of the proposed restaurant to the residential development to the north is approximately 350 feet via vehicular travel to the driveways located in the front of the homes. Next, staff finds that the applicant has proposed conditions to end alcohol sales at 2:30 p.m. each day, consistent with the closing time of the restaurant, whereas the Land Development Code would have allowed sales until 3 a.m. daily for alcoholic beverages. The proposed 4 COP wet zoning is requested, again, by a restaurant. However, the 4 COP category is not limited to restaurant use. Nonetheless, for the reasons discussed above, including the termination of alcohol and sales consumption prior to what would otherwise be allowed, staff finds the proposed wet zoning does not pose significant impacts on the surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances identified previously spoken. For the reasons above, staff finds the request to be approvable, subject to the recommended condition. Approval is based upon the wet zone survey indicating a total of 4,000 square feet of indoor area and 435 square feet of outdoor area for a total area of 4,435 square feet as shown on the revised wet zone survey submitted February 15, 2023. The condition is the sale and/or on-premises consumption of alcoholic beverages shall be limited to the hours of 7 a.m. to 2:30 p.m. Monday through Saturday, and 11 a.m. to 2:30 p.m. on Sunday. And that concludes staff's presentation, unless there are any questions.
Just a quick question. I don't see in the staff report the actual waiver amount and resulting setback. I did look at the wet zone survey, and so I just want to document that for the record. When I look at the wet zone survey that is dated 10/3/22, that's the drawing date rather, but it shows a resulting setback of 121.4 feet, and I just wanted to get your agreement that that would be, instead of the 250 requirement for the separation, the result is 121.4. Is that your understanding?
And that sounds correct. Let me look at the wet zone survey. You are correct, yes.
Okay, so that is so then by my math, that waiver amount is 128.6 feet.
That is correct.
Okay, perfect. All right, I just wanted to clarify that on the record. That was my only question.
All right.
Thank you so much. All right, is there anyone that would like to speak in support of this application? Seeing no one, anyone in opposition to the request? All right, Mr. Hisney, Mr. Lampkin, anything else?
Yeah, we apologize for not specifying a waiver distance in the report, and we immediately after this hearing will provide a revised report to identify that, which will be placed in optics.
All right, perfect. I'll take note of that. All right, then the applicant, sir, if you have the last word, if you'd like to take it.
No, ma'am, I don't have anything further to add.
All right, perfect. And you agree with those distance amounts that we discussed on the record with the planner?
Yes, ma'am, we do.
All right, perfect. Thank you very much. Then with that, we'll close special use AB 22-1721 and adjourn the land use hearing officer hearing. Thank you all for your time and testimony.